Hi folks, Alexander Haberbush here with your monthly legal update from the Lex Rex Institute. Actually recording this a day in advance this time because I will be in John Eastman's trial the day that you're watching this. For those of you keeping track, it is still ongoing. I think that we're in our 8th week at this point. This thing seems never ending. Might actually be longer than that. I've kind of lost track. So for those of you who know better, go ahead and correct me. But you can watch that online streaming via Zoom. We'll put a link in the description to this video if you're interested in watching it. And if you haven't been watching, now is the time to start because we're right in the middle of John Eastman's direct examination for his defense case. So you can hear it straight from him, exactly what he was doing and exactly what his intentions were for, the various charges that they've tried to bring against him. But that's not the primary reason that we're here tonight. Tonight we're here because of a couple lovely ladies that you folks heard from a little bit earlier. Those are actually two of my clients, Rachel and Susie, and their two daughters, who, of course, went to the Pali Science Camp as part of a school-sponsored project. We're told that it was a science camp, at least. Turned out to be a little bit more of an LGBTQ propaganda camp, where they were taught about preferred pronouns for the first time and housed with counselors who refused to identify their biological sex. And of course, the school refused to disclose that as well. I think Rachel and Susie have probably already talked to you about that. I'm here to talk to you about the case that we're litigating on their behalf. So we filed a lawsuit against both Pali and the school district. And you can't make this stuff up. Pali's response to our lawsuit was to file what's called an anti-SLAPP motion. Well, what that means is strategic litigation against public participation. In other words, they're claiming that our lawsuit is against their free speech. So by suing them, we're depriving them of free speech. What's their argument? Well, when our counselors were teaching this material, that was just free speech. Understandably, the court took that to be, the load of hooey that I think that any sensible and right-thinking person would obviously know it to be. But not to be deterred, Pali decided to appeal that anyway. They've appealed that to the Court of Appeals. By the way, we're countersuing them for attorney's fees because I don't think we should have to put up with any of this. But the story really gets funny because now that it's on appeal, Pali forgot to pay a $50 fee to get the administrative record from the lower court, got their entire appeal dismissed. So now our appeal is the only one left. They claim this is excusable neglect. They should be allowed to pay the fee. We don't think so. We filed, I think, a 7-8 page opposition last week saying you shouldn't be allowed to do that. Scathing. I highly recommend that you read it if you're interested in dry, boring legal writing. For those of you who aren't, I'm sorry that you have to listen to me for 5 minutes. The last case that I want to talk to you folks about is one where we actually need your help, and that's a case in the election law arena. So for those of you who have been following election law for any time, you've probably noticed that it's awfully difficult, or at least awfully uncommon, for lawyers to win challenges that are brought after an election is over. And there's a reason for that. There's a constitutional doctrine called mootness. And what that basically means is there has to be a present case or controversy in order for somebody to get relief. So for there to be a favorable judgment from a court. And what courts do is they look at elections that have already taken place and they say, well, the harm is in the past. Anything that we do would not be able to remedy that problem at this point because the election's said and done, somebody's already in office, therefore we can't do anything about that lawsuit. And we actually, crazy situation, back in 2020, we actually had some lawsuits where we would sue before the election took place and they would say, well, your suit isn't ripe yet because nobody's been harmed, because you can't have a lawsuit till there's harm. But then after the election was done, they'd say, well, now your case is moot, you can't have it heard. So there was maybe a 2-hour window on election day before the votes had been counted when you could actually hear the challenge. Totally outrageous. But the reason why this case I'm talking about tonight is important is it gives us a very good window to be able to challenge that doctrine and get elections recognized as one of the exceptions to this mootness doctrine. And that exception is called capable of repetition yet evading review. Now, basically the only thing the court currently applies that to is pregnancies. Because, you carry a baby for 9 months, the baby is born, but it can happen again. So you could have harm that occurs to a mother while the mother is pregnant, and then afterward the harm is done, but it's capable of repetition, but evading review from the court. We believe that elections are a lot like that because elections happen cyclically. They happen every 2 years, every 4 years, and those are the only time when you can really get relief on them. Well, this case that I'm talking about now is actually a case on behalf of a woman named Emily Wolfe. And Emily Wolfe applied to be a poll worker while there was a vaccine mandate imposed by the County of Los Angeles. All poll workers had to provide proof of vaccination. There was no way that she could seek any kind of medical or religious accommodation from this requirement. She was simply prohibited from continuing further in the application form if she had this issue. Well, the way that we got teed up through both the federal court, the federal district court, and then again at the Ninth Circuit Court of Appeals tees us up perfectly to challenge not on the merits ground, so not on whether or not it constituted religious discrimination, but on this standing ground, on the grounds of mootness. And if we could get this looked at, I think it presents a perfect opportunity to get this doctrine revisited and allow us to actually hear election challenges in the future. And that's because this is capable of repetition but evading review for a variety of reasons. Firstly, the election portal is only open a few months before each election. So it would be impossible for Emily Wolfe to even apply to be a poll worker most of the time. The other reason is that because of the nature of the pandemic, vaccine mandates were imposed, rescinded, and imposed again, also capable of repetition, but evading review. These things in conjunction with each other, especially in the context of an election challenge, I think perfectly tee up the facts in this case to be able to get rid of certiorari to the Supreme Court granted and actually get heard by the justices and hopefully change this standard so we can get some of these election challenges heard and win them. It is a targeted strike at the way our law currently works on this. And I think that the ramifications of a positive verdict on this could be overwhelming in the election law arena. Now, our deadline to file this petition for writ of certiorari and get our case heard, well, it's coming up. It's next Wednesday, the 25th of October, and we are shy of our funding deadline at this point. And as much as I would love to bring this case, I can't tell my board of directors that I'm bringing it if we haven't gotten it funded. And we are a bit shy of that goal. So if that's the sort of thing that you would like to have heard, we could really use funding on that. If you know anybody, I know we just had our taxes due last week, but if you know anybody who has tax deductions they need in the next year, seriously, this is the time and place to do it, because this election could seriously change the entire battlefield for election integrity. You can do that at lexrex.org/donate, and in the field you can just put Wolfe, WOLFE. We'll make sure it goes to the right place. I would love to bring that constitutional challenge, and I would hate to miss the opportunity. Again, that's next Wednesday, the 25th, that we got to bring that. And it'll take me at least a couple hours to do the petition for writ of certiorari on that. So ideally, we want to be funded before that. But that's all for this month's monthly legal update. That's what's going on in some of our cases. We got a lot more to talk to you guys about, but I guess we'll have to save that till next month. Good talking to you, folks. See you later.